Hey everybody, how's it going? Welcome back to Copper Jacket TV. So for me, the most important case currently sitting before the Supreme Court right now is Snope v. Brown. That's the case that's challenging Maryland's ban on so-called assault weapons. It's also the case where the appellate court said that they're not even protected by the plain text of the Second Amendment in a decision that was so horrendous that I just couldn't believe it. Reading through it is like reading something from an activist group or Mom's Demand, something like that. Not something you'd expect to be reading from a court that is supposed to follow the Constitution and Supreme Court precedent. Now, I've made a couple videos about this in the past, talking about how Maryland's trying to play games with this right now, but I'm going to be pulling out my crystal ball here because it looks like if we read the tea leaves, just based on what happened recently, just this last Friday, it looks like the Supreme Court actually plans on taking this one. And if they do, say goodbye to all of the bans in California, Illinois, Washington, Maryland, New York. I mean, you name it. These bans are all gone across the country. So let's talk about what just happened and why I think it's over for the bans. Okay, so let's go ahead and talk about what's going on here. Now, in order to understand what I'm talking about, and we're going to talk about what just happened on Friday as well, you first have to go back to when the FBC first petitioned the Supreme Court for certiorari back in August, okay? So back in August, I believe it was August 23rd, they filed for cert with the Supreme Court. Now, that means there is a month for Maryland to respond. So Maryland has to respond by September 23rd. Now, Maryland is a state that's got its own problems. They have a lot of things going on right now with other bans and red flags, and you know they've just fallen off the deep end. So there's a lot of lawsuits that are going on there. But Maryland said, hey, look, we're spread too thin with all these other lawsuits, people taking us to court, and so we don't have enough time, enough manpower to be able to address this in that 30-day period. So Maryland files for a 30-day extension. Now, they filed for that 30-day extension, and the Supreme Court granted it. That means now Maryland had until October 23rd to file their response to the petition by the FBC and by Snope. So that gives them plenty of time. This is a case that's been going on for a while now. They had time to argue at the district court level. They had time to argue at the appellate court level. They've already done their history and tradition and research. They've had their experts. They've given all their testimony. Like, everything's been done. There's not much more that you would have to do in order to take this up to the Supreme Court. They should have been ready for that, and they should have known that it was going to be coming just based on, you know, all the other times that cases like this has been brought to the Supreme Court. So again, they should have been completely ready, but for some reason, again, they didn't have the manpower. So they got that extension. Now, get this, before their extension is even up, okay, this is like weeks before their extension is even up, they decided to ask the Supreme Court for yet another extension out to November 22nd this time. So instead of being September 23rd, which was the first time, they had 30 days, that would bring it to September. Now we're looking all the way out to November. Now, I said in a video that I did recently that I think they're playing games in this case. The reason that they're doing that is they're trying to push all of this stuff out until next year. It's a lot like what the Ninth Circuit tries to do and California tries to do when they push things out over and over again, just trying to delay and extend the time so that, you know, maybe it doesn't even take place during this session or whatever. Because originally, this should have been set for conference on November 6th. But obviously now we're getting everything pushed out. Well, here's where things get very interesting. So they asked for the extension to November 22nd, which would, again, put them into next year, right? So we're looking at January sometime now before they even get a chance to file their response. The FBC actually files paperwork with the Supreme Court saying, or in opposition with the Supreme Court saying, look, they've already had time. You guys have already granted them an extension. You've given them enough time. This is something that's already been litigated. It's done at that level. They should have time to be able to take care of this. And so we oppose that extension because we know what they're trying to do. The FBC actually said if they get this next extension, we're going to be moving this case into next year. And so they wanted to avoid that. Well, the thing is that the Supreme Court kind of showed their hand here by saying, we agree with you, and we're not going to give them the entire extension. So what they did is the Supreme Court granted them another extension, but now their response is due by the 12th. What that means is, and that date is very important and very specific here, because if their response is due by the 12th, and they're obviously not going to get any more extensions if they didn't even grant them the full 30-day extension like they asked previously. But what this does is it keeps this case in conference for this year. Now, I don't think that the Supreme Court would have done something like that and granted the FBC's request in opposition if they weren't planning on taking the case. Because if they're not planning on taking the case, who cares if it goes into next year? It can go into next century for all they care, right? But if they are actually considering taking this case, they want to make sure that it's done in a timely manner where they can have a decision for it before the end of their session, because everything has to be wrapped up, right, by the end of the session. Just like last year, we saw all the Illinois cases get dragged on for about 6 weeks before they finally ended up, sending them all back down or whatever. But it got dragged out until the end of the session, and that was it. They had to be done by then. It's the same thing again this year. They have to be done by that particular time. So by the Supreme Court saying, no, we're not going to grant you that full term in your extension, we're just going to give you a little bit of time, and doing it at a date that would still allow for it to be heard this year, it looks like they're trying to give themselves enough time to be able to hear oral arguments and give a decision before that time frame is up. So for me, that was really important. Seeing whether or not they were going to deny or allow the additional 30-day extension was an important indicator. And so we got that decision from the Supreme Court last Friday, and now we know, again, that they're going to have to file their response. Maryland's going to have to file that response by the 12th of November, and we're going to have this thing set for conference, hopefully, this year. I mean, I can't say for certain because you just never know what kind of shenanigans go on behind the scenes, but nonetheless, it should be set for this year, and so we should have everything we need to know and everything set up so that we know whether or not they're going to accept or deny this case this year. Obviously, they could still push it off, right? It could be set for conference, and then they move it to the next conference, and then maybe the next conference, and maybe the next conference. You know how the Supreme Court works with this stuff. But just based on what they did Friday, by only giving them a little bit of time, I think that actually speaks volumes in favor for us. I could be totally wrong here, but just taking a look at everything, it seems like all of the puzzle pieces are fitting for them to be able to, take this case and again, have it done by the summer. So we'll see what happens. I am really excited for this one because again, the implications are so huge. People look at this and they think, oh, Maryland, it's a Maryland case. But when it goes to the Supreme Court, I mean, think about Bruin, right? Bruin was just a case dealing with Kerry out of New York. And it changed the Second Amendment landscape in our country forever, right? A simple Kerry case out of New York had that much of an impact on the entire country. Imagine what type of impact a case like this would have. And again, I mean, we've seen already just indicators from Thomas and others on what they feel about it already on these commonly owned semi-automatic rifles, which is what they are. They're nothing more, no matter what name you give them. That's all that they are. And I think that at least a majority of the Supreme Court understands that. And that's all we need. So I wanted to share that with you guys. I've got my fingers crossed and we'll be watching, but I think we're going to see this for conference this year. So anyway, I wanted to share that with you. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.